This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are now joined by Todd Lutsky from the law firm of Cushing & Dolan. The segment, Ask Todd. Why? Because you get to ask Todd your questions about your estate plan. So, studio number here is 888-205-2263. Usually we get room for 2 to 3 callers over the course of the segment, so make sure that you get in line if you got a question for Mr. Lutsky. That phone number again is 888-205-2263. One more time, it's 888-205-2263 to ask Todd your estate planning questions live on air. Mr. Lutsky, how are you today?
I am well. And you?
Pretty good.
Yeah?
Pretty good.
Just pretty good?
I spent a lot of time yesterday trying to find the word imposter in the dictionary, though. I was looking it up.
Yeah?
It turns out it's next to impossible.
Well, that would make sense.
So, who knew? Todd, I want to talk to you a little bit about state estate taxes. I know that we talk a lot about the federal estate tax, but let's say that you live in a state that has a state estate tax.
Yeah.
And you say, you know what, I want to, get rid of this. I don't want this to be a thing. Is that problem solved simply by moving to another state in all situations, or is that not the case?
It's definitely not that easy. It's an option. Moving could be a good option. There are, by the way, did you know that there are only 15 states that even have a death tax?
It's 30% of all states.
Oh, it sounds more when you say it.
30% of all states.
Yeah, 30% of all states. And Massachusetts, of course, has an estate tax, a painful one. And so, yes, people do move. In fact, I remember doing a seminar on changing domicile, saying, so you think you've moved from Massachusetts or you think you've changed domicile? Maybe not. It's not that easy. How do you do it? So if you want, you can simply make sure you move. And for at least the rules for Mass, I can't speak to every state. You got to make sure that you are out of the state for at least 6 months and a day. So that's important physically. Mm-hmm. And by the way, they'll check. So when let's say you're in Florida, if you're there, plane ticket is helpful. Credit card bills are helpful. Run in and out of Publix and go to the gas station. And, if you're there, you're doing those things. And then you want to change your voter registration. You want to change your driver's license. And quite frankly, you want to update your estate plan. Wouldn't think that, right? But remember, the trust is likely going to transfer with you. You might not have to change the trust. You can change the situs of the trust, but you don't need to change the trust. But you do need to change the will, the healthcare proxy, the power of attorney, and the HIPAA, the living will. Those basic documents, each state tends to have their own little nuances with those. So you're changing it, one, because of the nuances, and two, it shows further intent to be a resident of that state. That's why we did it. So very helpful there. So all of those kinds of things, club affiliations, etc. But also, don't forget about property. If you leave property in Massachusetts and you are a non-resident, you made the switch, and you still own property in Massachusetts, in a trust or in your name, they are going to tax it in Mass as a part of your entire estate, a percentage of the entire estate. So if you move, do all the things I said, and then don't forget about that Cape property. Put it in an LLC. If you put it in an LLC, you convert it to an intangible stock certificate, if you will, and now Massachusetts will not tax it as a non-resident.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you have a question to ask Todd about your estate plan, this is your chance right now, live on air. Phone number here is 888-205-2263. That number again is 888-205-2263. It's your chance to ask Todd your questions right now on air. That number again is 888-205-2263. Still have another spot or two available. So one last time, that phone number is 888-205-2263. Quick break, then right to your questions with Todd Lutsky.
Breaking business and financial news first throughout the day. Only here on the Financial Exchange Radio Network. The Financial Exchange Show podcast drops every day on Apple, Spotify, and iHeartRadio. Hit that subscribe button and leave us a 5-star review. You're listening to the Financial Exchange Radio Network.
All right, let's get right to your questions for Todd Lutsky. First up, we've got Charles in Methuen. Charles, what is your question for Todd Lutsky?
Hi, Todd. I have my wife and I have a trust.
Okay.
We also have we funded it in various places, but there was one place we were looking to transfer funds. We have a credit union, and the credit union made a suggestion that I've never heard brought up before, which was instead of putting our joint accounts at the credit union into the trust,
Yeah.
they suggested making the trust the beneficiary.
Okay.
Good idea, bad idea?
So, a couple of things. One, is the trust you have revocable?
It is a revocable trust.
And is it just one trust, meaning it's a joint family trust, both, or do you have a separate trust for husband and wife?
We have a separate trust for husband and wife, so one trust is the beneficiary, because obviously
Yeah.
we're joint owners.
Yeah. So
Yeah,
you
we
can
try
do
to
it.
come in-
You could certainly do that. So you can make the designated beneficiary of any account the trust. That would avoid probate, and it would get it to the trust upon your passing. I don't really know why why that would be any easier or any better than just naming the trust as the owner. I mean, to me, I usually just tell clients, look, just retitle the account to the trust. Now, and if it, depending on the size of the account, maybe I want to put, one account in one trust, one account in another trust, or, you could technically split the account if you wanted to. But I don't really think there's any major reason why I would do it one way or another. But I just, in general, always put the asset directly into the trust rather than name the beneficiary of the trust. But it will get there upon death, and it will get there in a way in which you avoid probate. So that's just my comment. But yeah, good question. It's not overly awkward, but I don't usually do it that way. So hopefully that helped a little. Folks, it is, getting really close to the end of the month here, and the guide is called Potholes to Avoid. And again, I think Charles's question is spot on. One of the potholes to avoid is, hey, did you do your estate plan, and did you ever fund it? Glad to hear they did it, and they funded it. So that's one thing to look at as a pothole to avoid, right? You want to make sure that if you've done your planning in the past, get this guide to learn maybe why you might want to fix it. Maybe you want to change and divorce proof your language to protect assets for your children. Maybe you moved, like Chuck said. Maybe we got divorced. Maybe we need to update our plan from a revocable to an irrevocable. Who knows? This guide gives you those ideas. It explains all the things to look out for when you're doing your estate plan first and foremost, and it explains, if you've done your estate plan, why maybe you might want to change it. So lots of good ideas in this guide, and it is getting close to the end of the month. So call and get it, 866-848-5699 or legalexchangeshow.com. You can download it right there. Again, 866-848-5699 or legalexchangeshow.com.
Todd, I got another one for you. Let's go to Ron on the Cape. Ron, you are on with Todd Lutsky.
Hi, Todd. Thanks for this show.
Sure.
Right before 9/11, my wife and I placed our oceanfront home on Cape Cod into a trust, and believed it was irrevocable. And now, so obviously, more than 21 years have passed, but a complication has developed in that beneficiaries were never named on a signed copy of the trust.
Okay, so stop right there. If you've done an irrevocable trust, you never list beneficiaries in the trust. There would be language in the trust that would say something like, and maybe you should check this, that would say, upon your death, and your wife's death, the assets are to be divided, I'll just guess, equally to my children. See, so that's how you name beneficiaries. Right in the document, it says, upon my death, I leave my assets equally to my children if living, otherwise to their children in the event I've died, the child has died before you. So check the document and see if it says that, because that does mean that's who your beneficiaries are. There's usually not a schedule of beneficiaries unless you've done a nominee realty trust, but that wouldn't be an irrevocable trust. So does that help a little?
It does help, because we did do an RN nominee trust, and that was filed in the registry. But the QRPT, the much longer one, that was never signed. It was never filed. So I have to maintain that the trust just doesn't exist, because we never signed a document listing our beneficiaries. And the firm is still around that helped us form it, but they don't seem to have any. And my question to you is, if a trust does not contain beneficiaries in a signed, notarized document, does the trust exist?
Well, I don't think you're going to get an answer on that, because I can't really follow this, because I don't. Now you mentioned a qualified personal residence trust. You threw in a nominee realty trust. You said one was irrevocable. So trusts exist because generally there is language in there that says where the assets go when you die. So like a nominee realty trust would have a schedule of beneficiaries. I don't think if it truly does not have a schedule of beneficiaries, if it truly does not list beneficiaries, it's possible that it hasn't satisfied the statutory terms for the trust to exist. But normally it's more so than does it exist, then you should maybe look and say, did you actually sign a deed transferring the property into that trust? So maybe it exists, but maybe it's just empty. Maybe it's doing nothing. I think in your case, the best I can do for you, Ron, from the radio standpoint, is tell you need to seek out a separate counsel and have somebody review everything that you've done so you can get a real handle on exactly what exists and what is owned by these trusts.
Todd, I've got one more for you here. Let's go to Patricia in Oxford. Patricia, only a couple minutes here, but what's your question for Todd?
My question is, we have a trust, and why should we put the life insurance policy and the retirement policy in the trust instead of having a beneficiary?
So what kind of trust, revocable or irrevocable?
Revocable.
So if you have a revocable trust, you never put, in either case, you never put a retirement account directly into a trust like that. You just can't. You can't move an IRA into either a revocable or an irrevocable trust without creating some kind of an income tax problem. Now, you could make the designated beneficiary on that account the trust after each other. Always make the spouse primary, and then the contingent could be the trust, depending on how you want to leave that asset, either through a trust to your kids or directly to your kids. A life insurance policy, if it's a revocable trust, no need to change the owner, but the beneficiary should be the trust and not the spouse, because by doing that, one, you're not only avoiding probate, but more importantly, on the first death, you're getting that life insurance money to flow into the trust. You want to get it in the trust on the first death, because it's the more assets you have in the trust on the first death, the more assets you can shelter for estate tax purposes, meaning they won't be taxed when the surviving spouse dies, thereby reducing your estate tax liability. So hopefully that helps you get an understanding on those two items. But folks, that's what it's all about. When you have a trust, this is a great question, Patricia. Make sure you fund your trusts. Otherwise, they're not doing anything for you.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure. Thank you.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated. Creating the right estate plan to help secure your future takes effort. There are plenty of mistakes that you can make, any one of which could have a dramatic and damaging effect on your financial strategy. Cushing & Dolan are experts in estate planning. Their brand new guide is called Detour Ahead, Estate Planning Blunders to Avoid. In it, you'll learn about these critical errors so that you can make the right decisions to always protect your assets. As an example, if you've created a trust more than 10 years ago and haven't updated it since, you're setting yourself up for problems. Cushing & Dolan's new guide will help you address issues like this. So call right now, 866-848-5699, and ask for your copy of our new free guide called Detour Ahead, Estate Planning Blunders to Avoid. That's 866-848-5699, or request it online from their website, LegalExchangeShow.com. That's LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and/or Armstrong Advisory may contact you offering legal or investment services. Cushing and Armstrong do not endorse each other and are not affiliated.